Hello.
Hi, Zoltan.
Sorry, I had some trouble with the Wi-Fi.
Good afternoon, sir. We will be starting with a short introduction from our end. Then you guys can begin with the discussion.
Okay.
Third year member of the report company. Dear participants, welcome to our panel discussion on emerging trends in international commercial arbitration. As businesses expand globally, the need for effective dispute resolution mechanisms becomes increasingly crucial. Hence, we gather here to explore the dynamic landscape of international commercial arbitration and delve into the latest trends shaping the field. Moderating our discussion today is Mr. Ayush Jain, a principal associate at Khaitan and Company in the practice of dispute resolution, and also the problem drafter for this year's moot proposition of the second RML NLU Kochar and Company Arbitration Moot Court Competition 2024. A 2016 alumnus of RML NLU, Mr. Jain is a dual qualified lawyer in India and England and Wales. During his university days, Mr. Jain has also been an accomplished mooter. His achievements include winning the sixth Lion Surrey International Air Law Moot Court Competition of 2015, held in Beijing, and securing the runner-up position at the Foreign Direct Investment International Arbitration Moot, held in the same year. I would now like to call Mr. Ayush Jain to introduce the panel. Please join me in extending a warm welcome to Mr. Jain.
Good evening, everyone, and thank you very much to the Moot Court Committee for organizing this and having me here to moderate this session on the emerging trends in international commercial arbitration. I would also like to thank you all for taking out the time to join this session today. As an arbitration practitioner, this is a fascinating subject because there is so much happening in the arbitration world in India and across the globe. It is an exciting time to be associated with arbitration, either as a practitioner, as an arbitrator, or even as a student. As we navigate through the complexities of the modern world, international arbitration stands, as they say, as the cornerstone of dispute resolution, continuing to provide flexibility, neutrality, and enforceability across borders. Several events in the last few years have shaped the landscape of international arbitration. The increasing use of technology, accelerated to a certain extent by the impact of the COVID-19 pandemic, conversations around artificial intelligence and how it will impact arbitrations and dispute resolution in general, increased focus on sustainability and environment considerations, evolving role of third party funding to facilitate access to justice. The list is endless. To talk about all this and much more on this subject today, we have a very distinguished panel with us. Our first panelist is Mr. Ajay Thomas. I'm sure many of you, particularly in the Indian arbitration fraternity, are already very familiar with him. Over his 19 years of experience, Ajay has effortlessly donned many hats as an arbitration administrator, arbitrator, advocate, and law teacher. He's presently an independent arbitrator and ADR consultant. Until recently, Ajay was the inaugural registrar and director of legal affairs at the Oman Commercial Arbitration Center. In the past, he has worked with several leading arbitral institutions around the world, including the LCIA and SIAC. He's a former member of the ICC Commission on Arbitration and ADR and was also the vice chairman of the ICC International Court of Arbitration's India Arbitration Group. He was a member of the expert committee constituted by the Law Commission of India to assist in the preparation of its 246th report on amendments to the Arbitration and Conciliation Act 1996. He's also a teacher and guest faculty member at several reputed law schools in India. We welcome you, Ajay, and thank you for taking out the time from your busy schedule to join us today. Our second panelist for today is Mr. Zoltan Novak. Zoltan is a partner at Taylor Wessing in Budapest. He's an expert in IP litigation and international commercial arbitration. He holds a PhD from the University of Debrecen. Zoltan is described by his clients as a dispute resolution dynamo. I was also reading somewhere that even though he's from Hungary, he was once appearing before a court in the United States, and the court was so impressed with his ability that they asked him to assist with issues, which is a unique distinction that even American lawyers don't very often receive. Zoltan regularly holds guest lectures at law schools and writes frequently on current legal issues. His work on major IP transactions got him and his team the Hungarian Legal Team of the Year in 2018 by Wolters Kluwer. We welcome you, Zoltan, and thank you for joining us today.
Hello.
The subject we are discussing today is quite vast, and I'm sure the three of us can spend several hours talking about what arbitration in 2024 looks like and what the future holds. But we will try and cover as much as we can in the limited time that we have today. We will also keep some time for questions, so please feel free to send in your questions to the organizing committee, and we will try to take up as many questions as we can at the end of the session. The first subject that we will touch upon today is something very important, is transparency. Confidentiality of the arbitral process is one of the hallmarks in arbitration. However, over the years, we've seen a systematic shift towards greater transparency. Institutions, arbitral institutions are introducing rules to make publication of awards the norm unless there is an objection by the parties. On this point, I would like to get you in, Ajay, here and get your thoughts on where you stand insofar as the confidentiality versus transparency debate is concerned, especially from an arbitrator's perspective. Ajay, you're on mute. I'm so sorry.
At the very outset, let me thank the RML NLU for this kind invitation, and Ayush for your very generous words in introducing and reading out my brief resume. And Zoltan, it's an honor and a privilege to be sharing a stage with you, albeit a virtual stage. So on that brief introduction, ladies and gentlemen, where do I stand on this confidentiality versus transparency debate? Well, as most of you know, transparency is one of those essential foundations on which the whole process of arbitration has been built on. Transparency my apologies. I think I said transparency. It's confidentiality. Confidentiality is one of those foundations on which the whole process of arbitration is built on. Transparency over the years has been considered as one of the foremost advantages as to why people choose arbitration vis-a-vis litigation. But if you see the manner in which arbitrations have been conducted over the years, especially in the region that we are in today, it has left a lot to be desired. So given that context, and if I may go back to that old saying, sunlight is the best disinfectant. So the disinfectant out here is transparency. So in my view, transparency is very much essential in arbitrations, especially in India, because the manner in which arbitrations are conducted, the quality of the processes that we see, and also the quality of the awards. So my argument in favor of transparency is from the perspective of A, improving the quality of the process. B, transparency, in my view, also improves the quality of awards, and improvement in quality of awards also essentially means that you would have lesser challenges in courts of law and lesser challenge applications being upheld by the courts. And all of that goes to bolster the credentials of arbitration as the most effective and when I say effective, not only cost effective, but also process effective method of resolving commercial disputes. And secondly, ladies and gentlemen, I believe transparency is important, or one aspect of transparency which can improve the quality of the process is something akin is a process what we call is publication of awards. Now, as Ayush very correctly mentioned, in recent years, there have been many institutions who have amended their rules to have publication of arbitral awards in a sort of anonymous manner, where details regarding the particular transaction, details regarding parties and lawyers involved in the process are kind of sanitized. And so this publication of awards, in my view, again, is a process which is only going to get more popular. If you look at this region that we are in, the wider Asian region, the SIAC has recently amended its rules to allow for sanitized publication of awards. And internationally, we all know that the ICC for many years has been publishing its awards in a sanitized form, which is available, which you can buy off the internet. So I think publication of awards, I think, is a very, very important way in which the quality of the awards and the quality of the processes will improve, because arbitrators will be very conscious that their arbitral awards will be in the public domain and visible to one and all. Secondly, I believe publication of awards also helps in the development of commercial law. Because as you know, for those of you from a civil law perspective, my apologies, those of you from a common law perspective will appreciate that precedents form a very important role when it comes to the jurisprudential, the jurisprudence of arbitration law and commercial law. So when matters, I believe when matters are, as arbitration gets more popular and there are more and more matters actually being decided behind closed doors and not in an open court, in a way, it stultifies the growth of commercial law. And this is also something, I think, which found resonance in a recent speech of Lord Chief Justice of England and Wales at a lecture, where he said that arbitration, I quote, "arbitration is hindering the development of common law by taking cases away from national courts and allowing commercial claims to be decided behind closed doors without any right of appeal and hence higher judicial scrutiny." So I do see a lot of sense in what Lord Justice Thomas had to say about the fact that the popularity of arbitration tends to be stultifying the growth of commercial law. So in addition to improving the popularity of the process of arbitration, improving the quality of the arbitration processes and quality of arbitration awards, I believe transparency manifested in the publication of awards will also aid to a very large extent in the in the growth of commercial law and arbitration law.
Yeah. No, interesting you say that, because I think another argument in favor of publication would also be that parties would be in a position to look at how the arbitrators are performing, how they are writing their awards, examine and assess the quality of the awards given by an arbitral tribunal. And therefore, be in a much better position to make an informed choice while deciding whether to appoint a certain arbitrator in the matter or not. So this is where I get Zoltan in and get your thoughts. Do you share the views of Ajay, and also how do you look at the recent amendment in rules where they say that unless the parties object, the norm will be, or the default will be, to publish the awards and make sure they are available in public domain?
Yes, so basically I agree. And most importantly, I agree on the point that the development of commercial law needs the publication of awards in a much more significant manner as it has been practiced in the past. Fortunately, or maybe as a good example, in Hungary, this has been the norm for the past 20 years or so. At least the most important decisions of Hungary's most important arbitral institutions have been regularly published in an anonymized or sanitized form. So only the legal relevance of the findings and holdings could be discerned from these awards. Of course, the parties remained anonymous, and also the exact case remained anonymous. And I think this is kind of a good compromise between transparency and confidentiality, because the fact remains that arbitration remains confidential in the sense that the general public will not be allowed to appear in the courtroom, will not be able to hear the witnesses, will not even be informed about the fact that an arbitration is going on between the parties. But as far as the major holdings are concerned, these are published, and these can in fact make arbitration even more accepted by the courts and by the general public. So I welcome this development.
Well, that's very
I had a
useful.
question for Zoltan. With the permission,
Please go ahead.
Ayush,
Please go
it's
ahead.
very interesting to know that in Hungary, publication of awards is quite the trend, or it's quite the norm. But I wanted to find out, what is the instrument which facilitates the publication of awards? Is there a provision in the Lex Arbitrii which says that, or is it something under the rules of the Hungarian arbitral institutions?
No, basically it's the practice of the institution that the most important decisions, just like the most important decisions of the High Court, are published. The institution goes through the decisions and publishes those that they believe are relevant for the development of the law.
Thank you, Zoltan.
No, that's very interesting, and a very fresh perspective. But just picking up on that, Zoltan, is this common across the EU, or is it just exclusive to Hungary, this habit or this practice of publishing awards?
I think I made no extensive research on this. My PhD is on another topic. But I suppose that there are several institutions in countries that follow this civil law tradition, where actually the case law is indeed relevant and has been relevant, even though not in the sense of precedents, but courts very, very eagerly follow precedents, even in civil law systems. And those countries where this practice is known and is followed, I think they share this practice, as do in the past couple of years some major arbitral institutions as well.
Yeah. Another aspect linked to transparency, something that I wanted to briefly touch upon, is third-party funding, and how the practice of getting parties to disclose who is the third-party funding institution in order to increase transparency. Ajay, how do you look at that? And especially as someone who has been with arbitral institutions, how are arbitral institutions with dealing with third-party funding and the requirements to get parties to disclose who is behind the funding?
Thank you, Ayush. I think that third-party funding, as you know, is a recent phenomenon, at least in India. Well, rudimentary forms of third-party funding have been in existence in India for a very long time. But until very recently, there were no definitive decisions from the courts in India which kind of sanctioned or gave the stamp of authority for the use of third-party funding as a process, mainly from an access to justice perspective. Yeah. So there was that uncertainty until recently, but I think now we are done and dusted with that uncertainty. There is certainty that yes, under Indian law, third-party funding is permitted, and there is no regulatory issue in actually carrying on third-party funding. The only I believe the only restriction is that the third-party funder should not be a member of the legal profession. That I think has been come across in a lot of decisions of the Supreme Court and the various high courts. So having said that, I believe third-party funding does help in access to justice to parties who have a good case on the merits, but who probably are dissuaded from entering into the process of arbitration by virtue of the costs involved in arbitration. Yeah. Let's face it, that's also a major issue when it comes to the process of arbitration. Arbitration may be faster and quicker than quicker, and it is said to be cheaper than litigation. But I think the last bit of it is quite debatable as to whether it is really cheaper than litigation or not, because arbitration is definitely a better process than litigation, especially for commercial disputes. But it's claimed to being less expensive than litigation, I think, is facing a lot of stress in recent years. And that is where I believe third-party funding comes to the aid of parties, because arbitration is not necessarily inexpensive. So whilst third-party funding, I think, helps in access to justice for parties who need it, I believe in India there is a lack of regulation when it comes to the concept of third-party funding. Unlike other Asian jurisdictions like Hong Kong and Singapore, we in India do not have any regulatory framework or guidelines which guide the process of third-party funding. And therefore, when third-party funding is involved, I believe more so donning the hat of an arbitrator, I believe it's very important for me, from a conflict of interest perspective, to know three things. One is to know whether there is an involvement of a third-party funder in the process or not. Yeah. Secondly, I think it's important for me to know the identity of the third-party funder. Now, identity is extremely important because this plays a very important role when it comes to judging my independence and impartiality.
That's right, yeah.
As an arbitrator, I am deciding the fate of parties in an arbitration. And therefore, it's very important for me to know whether there is any conflict that I might have with the funder involved in the process. Because if there is a conflict, then I would be conflicted out, and I would have to stand down from that arbitration. And thirdly, many a times, I think it's also important, from a court's perspective, to know the terms of the funding arrangements. Now, terms from the funding arrangements purely from the perspective of whether the funder will bear an adverse cost award or not. Yeah. So I'm looking at it. My interest in the terms of the funding arrangement is limited only to that aspect of the funding arrangement between the funder and the funded. So otherwise, as an arbitrator, I'm purely concerned only with whether there is the issue of whether there is the funding arrangement and the identity of the funder.
Yeah, no, that's right. In fact, like you said, as we see the evolution of third-party funding, I'm sure we will see many more developments, and this scheme, the whole process will become a lot more structured with some regulatory mechanisms in place in order to ensure that the fairness and the impartiality of the process is actually protected. The other theme that I wanted to touch upon, and I'm quite sure any discussion on emerging trends in international commercial arbitration in 2024 is incomplete without the India story. India's rise in arbitration. For several years now, we've all spoken about how India is slowly becoming a pro-arbitration destination and how we're working towards ensuring that courts and the legislature take steps to improve our image and bring India at par with London and Singapore as the preferred seat of arbitration. But just on the India aspect, how are you looking at the landscape, Ajay? And of course, we will have to go to Zoltan at some point to compare it with the EU perspective. But just from an India perspective, how are you seeing the landscape, the trend to shift to from ad hoc to institutional arbitrations? Also, I was reading a very interesting statistic that for the last 4 years, India is the highest user of SIAC. Indian parties are opting for SIAC, and that is a very encouraging development. How do you look at it?
Well, I think let me start off with a bit of historical perspective. We've all read that famous Guru Nanak decision of the Supreme Court of India, where the Honorable Supreme Court in the decision has said that the manner in which arbitrations were conducted in India made lawyers laugh and legal philosophers weep. Now, ladies and gentlemen, that was in the 80s. And that to a large extent continued in the 90s and the early 2000s. But thankfully, when we fast forward to the last few years of the first decade of the new millennium, we found that things have started improving tremendously. One of the biggest problems ailing arbitration in India was the attitude of courts towards arbitrations. The courts tended to veer more towards interference in the process. And as a result of which, the process, there was too much of what I would call judicialization of the process of arbitration. But thankfully, what has happened is that, but before I move on, I must say that this reason why the courts tended to interfere in the process of arbitration was not because they loved interfering in the process or they were threatened by the process of arbitration. Here, I must say something in favor of our judiciary. In my view, the reason why they interfered is because they were aghast by the quality of the process. At times, by the quality of the awards which they were faced with when these awards and when these arbitrations came to the attention of the courts. And that is why our judges, as they are trained to do complete justice, found ways and means of interfering in the process and correcting and doing what they thought was a course correction. But when you look at it from a wider international arbitration perspective, that was considered to be blatant interference in the process of arbitration. But thankfully, ladies and gentlemen, what has happened in the last 10 years, I would say 10, 15 years or so, is that the courts have made a course correction. The courts have realized that arbitration has been devised as a process which is an alternative to the courts. And therefore, the role of courts, qua arbitrations, should be one of support to the process rather than interference. And interference would be warranted only in what they call the rarest of the rare cases, which shocks the conscience of the court. And thankfully, what has happened over the years is now the courts, be it the Supreme Court or be it the High Court, I think they're very steadfastly stuck to this regime of support rather than interference. And if at all interference, only in the rarest of rare cases, which shocks their conscience. And courtesy that, ladies and gentlemen, I believe that this whole scenario or the landscape of arbitration has changed from what it was 15 years ago. And I remember 15 years ago, I was a counsel working with the Singapore International Arbitration Center. And every time I spoke in an international arbitration conference, people would always ask me, why are your courts so interfering in arbitration? When will India be a more arbitration-friendly jurisdiction? Ladies and gentlemen, I think we can, for those of you Indians, I think you can be proud of the fact that in the space of 15 years, I think the scene has changed drastically. It may take a very long time for India to catch up with Singapore and London and Paris as a seat for international commercial arbitrations. But what is very sure is that India has taken has come quite a long way on I would say, in that process of being a more arbitration-friendly jurisdiction. And that's the key takeaway, I believe. We today are a more arbitration-friendly jurisdiction. And this has happened not only because of the attitude of the courts and the support of the courts, but I think an equally important factor has been the role of the government. Because you cannot improve the arbitration landscape purely by the interference or the intervention, if I may say, of the courts. The government plays a very, very important role in the promotion of arbitration as a means of dispute resolution. Let's look at dispute resolution in India. As most of us know, in excess of 70% of litigation and arbitrations in India involve the government of India or the state governments or government-linked entities involved in the process. So when you're looking at improving the quality of arbitration, improving the popularity of arbitration processes in India, I think the government plays a very important role because it decides as to what should be the process that its contracts should have. Should it be litigation? Should it be arbitration? Should it be mediation? And in recent years, we have seen that there is a marked preference of the government, especially the central government, towards the utilization of arbitration as the most preferred means of dispute resolution. And this, to a large extent, also, I think, has been the influence of the World Bank's ease of doing business rankings. And that's been a big motivator for the government of India to actually improve the quality of arbitration processes, the quality of arbitration legislations in India. And that we see today that 5 years ago, India was probably 140 on the ease of doing business rankings. And today, India has leapfrogged to probably a ranking somewhere in the late 60s. And alternative means of dispute resolution, arbitration, mediation, and the processes and the efficiency of these processes play a very important role in the ranking weightage. And so whatever may have been the motivation for the government of India to reform the arbitration process, what is undeniable is that all of us practitioners of arbitration law and the end users of arbitration have benefited from that process, and which I believe has put arbitration and mediation in India on a very strong, solid footing.
Yeah. No, absolutely. Two key points before we take it to Zoltan. One is, of course, absolutely agreed on the approach of courts. I think I was very fortunate to be a part of the Docomo decision of the Delhi High Court, where the Delhi High Court acted with serious urgency in ensuring that the award is enforced and in 8 or 9 months, which was unthinkable earlier, the enforcement proceedings were done and dusted. The award amount was given out, and it was exceptional. And I think that was one of the decisions where we started to see really the courts actually walking the talk insofar as India's approach is concerned. The second point is something that I was recently talking to an arbitration practitioner, and we were discussing what has changed, the landscape of arbitration in India. And he made a very interesting point. He said, what 1991 budget was to the Indian economy, the 2015 amendment to the Arbitration Act was to arbitration in India. So that was the booster dose, and that radically changed the landscape of arbitration in India. But I want to take it to Zoltan at this point. We've of course heard the Indian perspective, but I'm sure all of us are very curious to understand where we are, at in Hungary and generally at a EU level. How are things in Hungary? How are arbitrations conducted in Hungary? Is it more ad hoc? Is it more institutional? If you could throw some light on that.
Thank you. Listening to your Ajash, very interesting points about India's recent history of arbitration, I kind of had the impression that this confirms my feeling that globalization has moved to Asia in the past couple of years. And what was the norm in Europe and in the Western Hemisphere 20 years ago is becoming the norm in India. And in Europe, maybe the situation is changing the other way around. I will talk a little bit about this in a second. But to answer your question about arbitrations in Hungary and in the EU, as you guessed, correctly guessed, our arbitrations are mostly institutional, and this may be a deviation or a difference when compared to your tradition. I am aware that the tradition, when arbitration emerged first at the end of the 19th century in commercial settings, in England, in London, in certain trade communities, it was an ad hoc institution, and it has remained pretty much ad hoc in London up to this moment. And institutional arbitration, from this perspective, seems to be a continental kind of phenomenon with very broad brushes applied here. And in Hungary and several other European countries, most arbitrations are institutional. What is a very interesting thing is that the main Hungarian arbitral institution, which is attached to the Hungarian Chamber of Commerce and Industry, was not founded after the transition to democracy. It's much older. It was established in the 60s when Hungary was still very deeply involved in the Eastern Bloc. And what is even more interesting is that it was not just a Hungarian phenomenon, it was an Eastern Bloc phenomenon. In fact, in 1976, if I'm not mistaken, the Eastern Bloc countries, so the Soviet Union and its satellites, signed what is called the Moscow Convention, which actually mandated dispute resolution between state-owned enterprises, and of course, most enterprises at that time were state-owned. International disputes between these socially state-owned enterprises had to resolve their disputes via mandatory arbitration. And these institutions, which still exist in this region, actually go back to this era. So our arbitral institution actually has a very long tradition. It started out as a mandatory institution for international arbitrations during the socialist era, and right now it is the main arbitral institution in Hungary. Otherwise, arbitrations, I think, are conducted in Europe and in Hungary in an increasingly standardized manner. So I would not be surprised if your arbitrations were conducted in a very similar fashion. Of course, it all comes down to who the actual arbitrator is, who the actual arbitrators are, but the standard format of holding um, a procedural conference at the beginning, and then memorials, and then a day or several days hearing at the end, and witness declarations and cross-examinations have become standard in Hungarian and in broader European arbitrations as well. And just briefly to go back to this topic that I threw up at the beginning, or raised at the beginning, as I said, Europe has traditionally been an arbitration-friendly jurisdiction, if we regard Europe as one jurisdiction, which now it is increasingly the case. But in recent years, there is a tendency which may go in the opposite direction. And of course, the most famous cases come from the investment arbitration arena, which is not our topic today. But very, very briefly, the European Commission and the European Court of Justice jointly came to the conclusion that there cannot be any investment arbitration between European member states. It would go against the spirit of the EU. And since then, intra-EU investment arbitration is basically dying slowly. But even commercial arbitration is being affected, and many, including myself, consider this as part of a broader tendency in which the European Union and actually other sovereigns all over the globe kind of move away from the consensus of the globalized economy that was prevailing 20 years ago, and try to control the economy in a more direct manner than it was the case during the globalization around 2000. And one of their targets is, of course, arbitration, which, as a private dispute resolution mechanism, is kind of the quintessential example of something that is not government controlled. And in fact, in a recent case, the European Court of Justice had to consider whether the Brussels regulation, which regulates, among others, the recognition of judgments in the member states or among or between the member states of the European Union, is applicable to arbitral awards. And it came to a very striking conclusion, in my view, even though it acknowledged that the regulation itself exempts arbitration from this regulation. So arbitration is not covered by the exemption. But then in a couple of sentences, it came to the apparently contradictory conclusion that arbitral awards still have to satisfy kind of the spirit of this regulation. And if they fail to do so, if arbitral procedures fail to comply with the general spirit and the general requirements of this Brussels regulation, which once again regulates recognition of judgment in the EU, then they cannot be recognized. And in the eyes of many, this constituted kind of the latest sign that the European Court of Justice would like to reassert its control over arbitration as well.
No, very interesting insight, Zoltan. But just from a practitioner's perspective, if I have to ask you, because I was reading recently a piece by a former president of the ICC, and the title of the piece was "Is Commercial Arbitration Entering in Dangerous Waters in the European Union?" So from a practitioner's perspective, if you have to list out very quickly two or three key challenges that commercial arbitration is facing in the EU, and more specifically in Hungary, what would they be?
Well, one of them would certainly be what I just mentioned, that the recent EU case law makes very old, entrenched dogmas of the arbitration community appear controversial, like the one that the recognition of arbitral awards are governed exclusively by the New York Convention, at least among states that ratified the New York Convention. Yeah. Another interesting aspect is what I also mentioned, the slow death of intra-EU investment arbitration. In this regard, I think part of this will actually give maybe an opening to commercial arbitration, in the sense that those investors that previously could rely on investment arbitration may be willing, or may be more concerned, or more motivated to sign investment contracts with state entities, which would secure their investment. And these contracts, if the case makes it necessary, could end up in a commercial arbitration. And maybe the third one is the once again epochal change that the Russian-Ukraine war brought with it, and all the sanctions and mutual sanctions that were introduced from the EU and US side, and on the other side from the Russian Federation on various businesses, which of course lead to commercial arbitrations in case contracts are frustrated or breached because of sanctions. It can also lead to investment arbitrations, which I don't think have any chance of being ever performed. And this all gives rise to a lot of very difficult conflict situations, because lawyers are now forbidden to work for certain clients that are sanctioned, but even sometimes the question is raised whether arbitral institutions may violate certain sanctions, probably not the EU sanctions, because they are exempted from the sanctions under the EU regime, but maybe US sanctions. So this whole sanction regime, and that parties cannot even process the payment of arbitral fees sometimes because of sanctions, and last but not least, also the impact of sanctions in terms of substantive law. That right now, if a contractual dispute involves the law of a country which either imposed sanctions or affected by sanctions or imposed countermeasures, these should all be considered as part of the applicable law, and arbitral tribunals shall consider whether these were imperative rules, whether they are applicable to the parties, whether they are mandatory provisions, and so on. So these times, and I come back to my starting point, these times sadly seem to suggest that the golden age of globalization is maybe changing in a dramatic fashion, and the old adage that business and international economic relations are the most important thing that moves the world together. Yeah. May not be tenable anymore, and commercial arbitration is part of affected by this.
No, interesting that you mention sanctions, Zoltan, because I'm sure it's going to be a recurring theme of 2024 with all that is happening around the world, the geopolitical tension, the Russia-Ukraine war. There are sanctions associated with China as well. Now, in India, we're not that impacted. I'm sure Ajay would agree. We haven't seen that kind of impact when it comes to India, but I'm sure this impact can be felt much more in the EU, UK, and the US. But just if I can quickly pick your brain on that, is it also how are arbitral institutions responding to the disruption from you of course mentioned at a substantive level what is happening because of the sanctions, but how are arbitral institutions in the EU generally responding to the disruption caused by, say, for example, arbitrations involving Russian parties or Chinese parties, wherever sanctions, or somewhere in some cases even Iran sanctions have been imposed?
Yeah, actually, there are two sides maybe of this coin. European arbitral institutions cannot really do too much. Most of the arbitral agreements that were signed, concluded by Russian parties, designate European arbitral institutions. And right now, if a case arises, they have to handle it. If the parties still see any chance of succeeding on either side, because as I mentioned, right now, if an arbitration starts in the EU against the Russian party, chances are that it will not be, it cannot be enforced, and maybe a parallel proceeding in Russia will be started by the Russian party. Yeah. and all this. What these arbitral institutions can do is very limited. They can make sure that they are exempted from the sanctions, which is quite clear on the EU level, meaning that it's not a question that just because an arbitrator is appointed in an arbitration between a party and the sanctioned party, he's not violating the sanctions. So this is clear. What they can also do and sometimes do, for example, the LCIA, I think did, is that they negotiated an agreement with their controlling authority, that they can process payments, or the sanctioned parties can process arbitral fees, so the arbitration can go on. The other side of the coin is what the parties can do in such situation. For example, the sanctioned parties who maybe no longer trust European arbitral institutions, and based on news reports, actually some of them do consider Asian arbitral institutions, for example, SIAC and the Hong Kong Arbitral Center. So if Indian parties now increasingly go to Singapore, they may meet some Russian parties on the floors there.
Well, I had
Yeah.
something to add, Ayush.
Yeah.
I wonder where all of these sanctions leaves London's, London's position as a hub for international commercial arbitration, as a leading hub for resolving commercial disputes. Because I have reason to believe, and Zoltan can correct me on that, if you look at the English commercial courts, more than 60% of the cases involved Russian parties, Russian oligarchs. So I wonder what has happened to, I don't have any statistics, recent statistics since the Ukraine war, but I wonder what's happened to all those litigations and arbitrations involving Russian parties. Because I know one of the hottest markets for the LCIA in London was the CIS, Russia and the CIS. So it'll be. I mean, if you have any thoughts or any insights into where do all these sanctions leave London's position as a hub for resolving international commercial disputes, at the EU level and the wider global level, because I believe these sanctions would be a big hit to London's position as one of the leading arbitration hubs of the world.
No, just before Zoltan picks that up, I just want to add, it's a massive impact. Absolutely. I was talking to practitioners in London who were telling me that almost all of the leading law firms have closed down their offices in Russia. They had a huge presence in Russia. In fact, a lot of these EPC matters where Russians were involved, involving, construction of ships, etc., that has stopped. That has come to a standstill, leading parties to, in the middle of high and dry, in the middle of contracts, where to go, what to do. Even if you get a decree or a judgment from a court in the UK, will it be enforceable? So all those things, there's a lot of uncertainty. But you're right. It's bound to have an impact on London as a preferred seat of arbitration. And like Zoltan said, perhaps the move will be to Asian arbitral institutions. And Zoltan, I leave it to you to take that up.
No, I actually I agree with this. Of course, time will tell, and of course now everything is up in the air. But there is a tendency in this direction.
Yeah. The other theme that I wanted to pick up, I know we've completely run out of time, but I think this is such a vast subject that there are so many things we can touch upon. But the one last thing that we wanted to pick up for today is the issue of conflict of interest and bias. In one of my recent matters, there was a challenge to the arbitrator on the ground that a relative of the arbitrator was a partner at the law firm which was representing the other side. So therefore, and the challenge was obviously rejected. But we're seeing this is becoming a common phenomenon. I don't know, I have no statistics to back this, but we're seeing far more challenges now. We've seen with the advent of social media, a recent high-profile arbitrator had to resign because of some comments he had made on social media in the past that were, unfavorable to one of the parties in the arbitration, and therefore he had to resign. So Ajay, from an arbitrator's perspective, how do you look at it, and how important it is that while parties are able to select the arbitrators, the fairness and the integrity of the entire process is protected?
Ayush, I believe the 2015 amendments have been a game changer. Prior to the 2015 amendments, a lot of us in India, be it arbitrators, arbitration practitioners, even judges in the courts, had a very hazy notion of what constitutes conflict of interest. What is conflict of interest in an arbitration scenario? But thankfully, as you know, the 2015 amendments to the Arbitration Act have introduced two schedules, the 5th schedule and the 7th schedule. And to a large extent, Zoltan, the 5th schedule mirrors the provisions of the orange list of the IBA guidelines on conflict of interest, and the 7th schedule to a large extent is based on the red list. So I believe, courtesy the incorporation of these guidelines now into the statute, there is a greater sense of certainty as to what constitutes conflict of interest and what are those circumstances in which an arbitrator should make a declaration constituting conflict of interest, and what are those circumstances in which an arbitrator should absolutely desist or refuse to to accept appointment as an arbitrator. So I believe, thanks to the 2015 amendments, greater clarity on this concept in India. But at the same time, having said that, conflict of interest is a very, very big issue in arbitration in India, and not only in India, I think the world over. Because let's face it, ultimately, most end users of arbitrations and lawyers are only focused on winning an arbitration. Winning is all what matters. So I think it is in that context that we need to look at, these issues of arbitrator bias. And all I can say is that courtesy, greater definition, and in the law today, I think we are on a more solid footing. Everybody is on a more solid footing, be it the courts, be it arbitrators, be it lawyers, as to what constitutes lack of independence and impartiality when it comes to arbitrations in India.
No, that's very, very insightful, Ajay. Zoltan, from your perspective, I mean, given the age we are in, given everything is out in the public, there's the databases available of arbitrators, the positions they've taken on certain issues, the matters they've appeared in. There are websites and websites coming up every day that have a full database ready of arbitrators' history. There's the age of social media where everyone is commenting, expressing their views on various subjects. How do you see it? And how do you see this having an impact on arbitrations and the potential conflict of interest? Is it only actual bias or the apprehension of bias that has to be looked into?
Well, actually, I would step one back, and I agree with Ajesh that the main systemic kind of a problem or risk, or kind of it's natural, but that parties want to win, and of course for this reason they want to select an arbitrator who they believe will be favorable to them. I think the problem comes from the fact, and this whole conflict of interest question is partly based on the fact that the arbitration community is still seen as being an exclusive club, kind of, and so and there are the insiders who know who the good arbitrator in their case could be, and there are the outsiders who may receive a claim or may find themselves in the claimant seat, but they never intended to file a claim, and their lawyers know nothing about this whole world of arbitration. And this is where a conflict of interest comes into play, because of course if one party has very good connected lawyers who even act as arbitrators sometimes along with the arbitrators that they want to appoint, that's a different scenario compared to someone who is completely new to this whole case. They just goes through the list, doesn't know anything about anyone. Maybe he has to review the LinkedIn posts to find some clues. And I think this is the systemic problem that I think if arbitration needs to remain, if arbitration wants to remain the leading dispute resolution mechanism that it currently is, it needs to be resolved. And I think one way to resolve is to make some improvements in avoiding double hatting a little bit more. And of course, I know this is a very difficult question because it is so much part of the system. But I think if we want to bring arbitration to the next level, we may want to find ways to deal with these issues. And maybe people could start to think of themselves more of arbitrators or more as counsels in certain periods of their life, for example. And this could be a way of solving the problem. Until this happens, one can read the Facebook posts and try to challenge the arbitrators based on this.
There's something I wanted to add to what Zoltan said. Whatever Zoltan said, it takes me back to a question which was asked to the late Professor Martin Hunter many, many years ago in his early years as a counsel and one of the founders of Freshfields arbitration practice. So he was asked as to who, in your opinion, is a perfect arbitrator? And Professor Hunter's response was, my perfect arbitrator, now as a counsel, would be somebody who has the greatest sympathy to the cause of my party who I'm representing, but with the least appearance of bias. So I think that perfectly sums up, what lawyers and parties are looking for when it comes to appointing arbitrators. How do you walk that thin line, of having sympathy to somebody who's nominated you, but being unbiased? I think it's an ethical dilemma which a lot of arbitrators, especially young arbitrators, are faced with, because many times the lure of greater appointments, repeat appointments, is very, very strong when it comes to younger arbitrators.
Yeah, absolutely. Absolutely. No, very, very insightful. I think both points that you've made. The other subject that I also really wanted to touch was artificial intelligence, and especially the impact of generative AI on arbitrations and how it's impacting what is happening in arbitrations. But we've completely run out of time. The organizers have, really asked me to stop now. So I will open the floor for questions. Otherwise, we won't have any time for questions. I will open the floor. I will request Ishan if you can post the questions, whatever questions have come up on the chat box, and we will fire them away to the panel.
No questions in the chat box.
Hello, sir. This is Yash. We have one question on YouTube. We're just posting it in the chat box. Till then, we have all the audience members or the participants of the competition. If they have any question, we'll just let you know in like 1.
Absolutely.
Hello, everyone. The floor is now open for question and answers. If any participant has any question to ask, please raise their hand. Yes. I'll just take your question from them. Yes, please.
Yes. Sir, we have a participant who want to ask a question. He's here only. He'll be asking a question through this mode.
Please go ahead.
Yes, good afternoon, sirs. Thank you for the session. And my question is as hereunder. So we were talking about the Indian judiciary and their approach towards the pro-arbitral arbitration approach. However, what we see these days is a dichotomy, wherein many of the courts are pro-arbitration, but regardless of that fact, there are some issues which keep on popping in the judiciary multiple times. For example, the issue of stamping in the arbitration agreements, which was, as long as I can follow it, started back in 2018 or 2016, even with the Garware Waldrop's case. And then we recently have another issue which has recently popped up, which was indeed decided by the Supreme Court about the powers of a court to modify an arbitral award, which was although decided by the court that it does not have the per se power, but now again the court is reconsidering this question. So what, and this question is to both of the panelists, what is the underlying cause that the panelists think that the courts are following such an approach, where although pro-arbitration, they keep on considering multiple times one issue or the other again and again? Thank you.
I think that's an excellent question. Ajay, you want to take that up first?
Yes. I think first things first, I believe the issue about stamping has been resolved now by a 7-judge constitution bench of the Supreme Court. So the issue of stamping has been resolved. So I think that, and there are quite a few pressing issues which have been brought before constitution benches. The issue of bias is also now pending before another constitution bench. And the good thing about all of this is that a lot of dicey matters relating to arbitration, where there's been divergence of views from concurring benches of the Supreme Court and from the varying high courts, have now reached the Supreme Court, and they have actually are now being considered, thankfully, in an expeditious manner by constitution benches of the Supreme Court. And that effectively means that if it's decided by a constitution bench, a 7-judge bench, for example, it's pretty much going to be the law for until there is a change in legislature. I agree that it's not an ideal situation. There is lack of uniformity when it comes to decisions by concurring benches of the Supreme Court and also from different high courts. But that's a price you pay for being as large a country as India, where you have so many different high courts, and also and one solution to probably all of this is probably having dedicated benches at the high court level, which deal only with matters relating to arbitration. Now, this is not something which is unheard of in other jurisdictions in the world. Hong Kong, for example, and every jurisdiction for that matter, which aspires to be an arbitration hub. And India today is also aspiring to be an arbitration hub. And I think, therefore, one plausible solution, I'm not saying it's a watertight, foolproof solution, one plausible solution would be to have dedicated arbitration benches at the high courts, and if possible, also at the Supreme Court.
Thank you, Ajay. We also have a question in the chat box. I'll take that to Zoltan. It says, how common is hot tubbing in international commercial arbitration, and what's your opinion on its practically as compared to the traditional system?
It's pretty common now. So basically, expert evidence has become very widespread, I think I just mentioned earlier that one of the old advantages of arbitration, namely that it may be or was more cost effective, is now called into question. I think it is still a selling point, or can be a selling point, but mostly only because the procedure is shorter, because there is no appeal. This makes things easier, but in terms of complexity, a standard international commercial arbitration now is very complex, and part of the complexity is that parties want to prove a lot of things through experts. Every party hires their own expert, which is basically a good thing. I think it is better than a tribunal appointed expert in many cases. And then because both experts, of course, are very good and are very well paid to prove the point, they will have different perspectives that the tribunal will need to resolve. I think principally, theoretically, this is a better way of resolving differences between experts than appointing an expert by the tribunal who the tribunal will want to believe, no matter how understandable the expert opinion is. I think if both experts are heard together, then the tribunal will at least have a chance to understand the issues really. And I'm a big believer in that lawyers can understand things other than law, even technical things, if the problem is explained to them in a good manner. So theoretically, this is, I think, the right solution. Practically, it makes things very expensive.
Yeah. No, thank you, Zoltan. There's one more question. The panel, can we take do we have time for a couple of more questions? Ajay and Zoltan, happy, can we take up a couple of more questions?
Sure, why not?
Yeah. There's one more question, which is, what is your take on the transparency versus party autonomy in debate, perhaps in ESG disputes? Interesting. I mean, this is something that we touched upon, of course, the whole publication of awards. But I understand, what the context is, that when it comes to ESG disputes, I mean, the issue is a lot more sensitive, and I'm not sure parties would want to, allow details about their ESG compliances, non-compliances, or any dispute to come out in the public in the form of publication of an award. So how do you see this, Ajay, when it comes to ESG disputes?
I must admit, I've had no experience or exposure to ESG disputes. So probably I may not be the best person to actually answer this question.
Zoltan, you want to take that up?
I will take this up, and not because I had any experience with ESG disputes, but I think the question is interesting because it also, and this is another topic besides AI that we could have spent the whole time today talking about, because it's also one of the hot issues of the day. ESG. I think my understanding of ESG is that it's a new type of norm, which is not the strict legal norm as my generation at least, studied it and learned it at the university. What one may do, may not do, must do, and everything is crystal clear. Of course, not crystal clear, but courts will use standard interpretation to find the meaning. ESG is something new. ESG requires companies to set goals that the regulation or the legislation doesn't tell them exactly what they should be. They just tell the companies they must set certain goals. They must set goals to improve environmental friendly things, to improve diversity, to improve accountability within the company. Now, if they set standards that are not ideal, then I can imagine that there will be a party, and actually there are already attempts to do that in terms of climate litigation, when certain stakeholders in a society file claims against companies. So far, not arbitration claims because there are no arbitration agreements, but maybe it will come to that. They file claims saying they didn't do enough to promote or to reduce climate change or to promote the protection of the environment. They should do more. Now, how such a dispute can be resolved using our profession as we learned it, I don't know. Maybe the new generations, the students in the audience will already study tools and how to solve such disputes. And one final point: 100 years ago, when commercial arbitration started to rise from the shadows of state to state disputes where it started out from, commercial arbitration began as an alternative dispute resolution method, meaning that the decision is not necessarily based on the law. And this is what is still in the rules. This possibility is still in the rules, and it is called equo e bono decision. When the arbitrator looks at the parties, listens to the arguments, and doesn't care what the law says, he just makes a decision based on his own consciousness and own feelings. Maybe ESG disputes where there is no hard law, where it's only soft law, if there will be such disputes, they will be resolved in this way, ex equo bono. Maybe ESG disputes will bring back the good old days of arbitration as a cheap and efficient dispute resolution mechanism. But this is just a dream at this point.
Well, that's a very interesting perspective. Thank you, Zoltan. Yash, do we have any more questions from the audience?
I'll just ask that.
Do we have any more questions? All right, thank you.
No, sir, we do not have any questions.
Then I think that I can see one final question on the chat box. Actually, two questions, but I think we'll just have time for one. That question is for Zoltan. It says, how can an international arbitration award be enforced in the EU and Hungarian jurisdiction? It's a vast subject, Zoltan, I understand, but I'm sure the listeners are very curious to know how enforcement proceedings are taking place in Hungary. If you could throw some light on that very briefly for us.
Well, Hungary and all member states of the EU are signatories to the New York Convention. And so basically, arbitral awards can be enforced and recognized under the New York Convention. Arbitral awards, yes. Actually, this is not the most this is not the easiest way of recognize a foreign decision within an EU member state, because the EU itself has its own regime of recognizing domestic, intra-EU court judgments. And the recognition and enforcement of intra-EU court judgment is a bit easier than recognition of foreign arbitral awards under the New York Convention. And therefore, if you have to decide whether to start arbitration somewhere or start court procedure in the EU against a defendant in the EU, there is an argument to be made for court procedure because enforcement is slightly easier. But other than this, actually, New York Convention prevails and is in full force. My only caveat here is what I said about the recent EU jurisprudence, which I think kind of challenges the big and exceptional place that the New York Convention is usually assigned. But so far, there is no question that a foreign award will be enforced in Hungary and the EU based on the New York Convention. Of course, under the usual exceptions like public policy and so on.
Yeah. Thank you, Zoltan. Very useful. Just before we bring this session to a close, I have an interesting exercise that I want to do with the panel. It's a quick rapid fire. The question is, how do you see, if you have to describe the outlook for arbitration in 2024, what will be the one word that you will use to describe the outlook? I'll take that to Ajay first. Rapid fire, one word. Outlook for arbitration in 2024, according to you. So you're on mute, Ajay.
If I may use two words, very promising.
Very promising, indeed. Very promising, indeed. Zoltan?
Life sciences arbitration and all this stuff. This is once again something we didn't talk about, but in the emerging industries there is huge potential, and despite all the kind of challenges that arbitration faces, there is huge future in these fields, in these emerging industries. So I'm very optimistic in this regard.
On that note, thank you so much. I would like once again to thank our distinguished panel for joining us today. I would also like to thank the organizing committee for putting this very interesting and engaging session for all of us, and the audience sitting there. We can't see you, but I'm sure you've heard us very patiently and intently, and for all your questions that have been posed to the panel. Finally, I would also like, on behalf of the panel and me, to take this opportunity to wish all the participating teams all the very best for the competition. We will, of course, all three of us will see you over the weekend at some point. But just wanted to send across our best wishes for all the participating teams.
I concur.
Thank you,
Yash,
Ayush.
is that all?
Yes. Thank you so much, sir. So it was a very, very informative session, and we at the Moot Court Committee and at NLU Lucknow believe that it will be very helpful for all the participants as well as all the listeners to this innovative session. Thank you so much. We are waiting to host you here.
Thank you.
Thank
you very much.
Thank
Bye-bye.
you.
Thank you.
Bye for now.
Bye.
Thank you.
Bye. Thank you.